Evening, everyone. My name is Brene Lloyd with Northwatch. I am joining from Robinson Huron Treaty Area. Northwatch's area of interest and our membership is Robinson Huron, Robinson Superior Treaty Areas, the southern, southeastern sections of Anishinaabe Nation territory, and the unceded Algonquin territory along the Quebec-Ontario border. And I'm joining from where Kebowek Algonquin territory meets Nipissing territory, just very close to Trout Lake in the North Bay area. And I'm really pleased this evening to welcome Kathleen Rosemer and Laura Tanguay, who are our presenters this evening. Both of them are PhD candidates. Kathy in energy and environment policy at Michigan Tech, and she anticipates completing her PhD program this year. And she did until recently work for 13 years as environmental director for the Sault Ste. Marie tribe of Chippewa Indians and was on the National Tribal Water Council. Laura is a PhD candidate at York University, where she researches mechanisms and discrepancies of consent in nuclear waste siting in Ontario. And she recently co-edited and co-authored chapters in a published report operationalizing Indigenous-led IA. And Laura works as an educator and in the policy space on topics related to environmental justice. So welcome, very appreciative to Kathleen and Laura for joining us this evening, and to all of you who have joined us as participants. And now I'm going to turn the evening over to Laura. Laura and Kathy, welcome, and go ahead.
Okay. We have broken our presentation into 4 sections, and we're going to take turns on this one. I will be starting with an overview of the UN Declaration on the Rights of Indigenous Persons and what it means when they say free, prior, informed consent. And then Laura will take over with Indigenous-led IA in the nuclear framework. I will come back in with energy justice and how the Anishinaabe harvest ethic can be used in framing energy justice. And then Laura will finish up with consent and nuclear waste siting. So Laura, if you would start. Flip the slide for me.
Sorry, Renee, I'm going to have to get you to do that. It's not working on my end there for some reason.
Thanks. So just to start with the UNDRIP and the meaning of FPIC, the 2 pronounceable acronyms they bequeathed on us in 2007. Next slide. The UN General Assembly adopted the UNDRIP on September 13th in 2007, and then all the literature around it was called a triumph for justice and human dignity. This was the ultimate result of 2 decades of negotiations between national and Indigenous governments. And despite all of that, next slide, lots of protests and lots of parades and letting the UN know this is important. Next slide. 143 nations, can we go back one? 143 nations approved it in 2007 and 4 voted against, including Canada, the US, Australia, New Zealand, the 4 with the most recent history of colonization, forming their nations by colonization. Next slide. The UNDRIP consists of 23 preamble statements, so it's quite, everybody had their fingers in the language wordsmithing on this one. And it solemnly proclaims the United Nations as a standard of achievement to be pursued in a spirit of partnership and mutual respect. And it consists of 46 articles. Next. I won't go through all of the articles, but just to let you know what it covers, rights of self-determination, rights of the peoples to protect their culture through their cultural practices, education, religion, etc., to use their own type of governance and to economic development. Certain health rights are specified, protection of certain subgroups that are more vulnerable in colonizing societies, land rights, from ownership, including repatriation or return of the land, to environmental issues. And I'm sure that that was part of the reason for the 4 holdout nations. And then there's several articles that describe how this is to be interpreted into the future. So the ones I'm going to focus on, Indigenous peoples have the right to the full enjoyment as a collective or as individuals of all human rights and fundamental freedoms. That seems like a basic one, but it's Indigenous peoples are free and equal to all other peoples and have the right to be free from any kind of discrimination. So these are just very basic human rights statements. Next slide. And now getting into the interesting parts from where environmental work positions ourselves. Indigenous peoples shall not be forcibly removed without free, prior, informed consent, and they have the right to their religious traditions, customs, ceremonies, and have access in privacy to their religious and cultural sites. So this is one where land rights come in. Next slide. And next again. The right to participate in decision-making in matters which would affect their rights. So I'm going to come up against that later in the energy justice framework through representation chosen by themselves in accordance with their own procedures. So we can, I'm sure, think of a few cases where that has not been happening in Canada. States shall consult and cooperate in good faith through their own representative institutions with the Indigenous peoples. In order to obtain their free, prior, informed consent before adopting and implementing legislative or administrative measures that may affect them. There are some tricky language regarding free, prior, informed consent, which I'll be getting into. The next 24 and 25 covering traditional territories. And I'm sure this is the one that gave a lot of those people who held out the heartburn. They have the right, go back, please. They have the right to maintain and strengthen their distinctive spiritual relationship with their traditionally owned or otherwise occupied and used lands. So they have the right to do this. And I'm sure that that was not something that most of the colonizing nations really were happy and content signing on to. Next. Next slide. The right to the lands, territories, and resources which they have traditionally owned, occupied, or otherwise used or acquired. And there you have the rub. This is where the right to own, use, develop, and control those lands that they possess by reason of traditional ownership or other traditional occupation and use. So here's where we have the problem. And then down in Article 28, again, we'll have restitution, compensation for the rights that have been taken or rights that have been damaged without free, prior, informed consent. So next slide. So there's some very powerful words in here, but of course it has no legal standing. It's a UN resolution. Next slide. Article 29, the right to the conservation and protection of the environment, including the productive capacity of their lands or territories and resources. And then the big one, states shall take effective measures to ensure that no storage of or disposal of hazardous waste shall take place in the lands or territories of Indigenous peoples without free, prior, informed consent. Now, you might have noticed a little bit of wordsmithing here. Free, prior, informed consent is actually only required in this one, storage or disposal of hazardous waste and hazardous materials, and in the relocation one. It's not a requirement of any of the others or of the UNDRIP overall. Next slide. And next. Article 32, right to determine and develop priorities and strategies, and that states shall consult and cooperate in good faith prior to the approval of any project affecting their lands or territories, particularly in connection with the development, utilization, or exploitation of resources. Next slide, please. And again. Next slide. So, free, prior, informed consent. it became pretty evident between 2007 and 2013 that states were quite confused about the meaning of free, prior, informed consent. If you could go back one, please. In September 2013, the UN Office of the High Commissioner for Human Rights published a document, What is Free, Prior, and Informed Consent? That states must have consent as the objective of consultation before any of the following actions are taken. And that it just says the objective. It doesn't say they must have consent. They just must have a consultation with that as its objective. So it's quite toothless. And go on, next slide, please. The only ones that require them to obtain consent are relocation and storage or disposal of hazardous materials. But the definitions of these words needed to be spelled out as well. Free, no coercion, intimidation, or manipulation. Prior, sufficiently in advance of any authorization or approvals or commencement of activities. And informed means that information is provided that covers the range of aspects, including reversibility, including the scope, the purpose, environmental impacts, etc. Unfortunately, the UN did not seek in this document to define the word consent. They use it a lot, but they did not define it. And that loophole was exploited, as I'll get into next. Next slide, please. And the next slide. U.S. recent history falls far short of the UN standard. Bill Clinton issued an executive order on consultation and coordination with Indian and tribal governments with no mention of FPIC. Barack Obama reaffirmed that with the memorandum on tribal consultation, again with no mention of FPIC. And this was 2 years after the UNDRIP had been passed. Go on, next slide. The consultation policies, in response to the Obama memo, all the government departments were instructed to generate consultation policies. And those were developed over the period up to and including 2012. And of the 45 policies I looked at, 0 included the language of FPIC. And in 2010, next slide, please, the State Department announced, after a thorough review of the declaration by the relevant agencies, I guess it took them 3 years, it is in the spirit the United States today proudly lends its support to the UN declaration. The US did not vote in favor of it in 2007, and under the Obama administration, they decided to do that. However, on that 15-page document, next slide, and another one, on page 5, includes the lines, in this regard, the United States recognizes the significance of the Declaration's provisions on FPIC, which the United States understands to call for a process of meaningful consultation, but not necessarily their agreement of those leaders. Now, I don't know what language they were speaking, but in English, consent means agreement. It certainly does when we're talking about sexual politics. I don't appreciate if someone takes me out and consults with me thoroughly about what I might want to do, and then just takes that he doesn't necessarily need my agreement. I don't think anybody would agree that consent does not mean agreement. And that is despite the fact that FPIC is actually only the objective in most of the articles of the UNDRIP. It's only a requirement in the 2 that we talked about: storage and disposal of hazardous materials and relocation. So the US response to FPIC was incredibly sad. Next slide, please. And next slide. Canada's endorsement came in November of 2010, so the same year as the US. About, what was the date on the US? December 2010 was the US one. And formally endorsed, but again, similar weasel words. While the declaration is not legally binding, endorsing it as an important aspirational document. So it's, yeah, we'll endorse it as long as we don't have to actually do it. So it's really quite discouraging when you look at the power of that could have been in this document, the amazing agreement, and then than the way they weaseled out of actually doing it. That's the end of my section. Now it's Laura's turn.
Thank you so much, Kathy. I don't know if I'm having some issues here or if it's the my internet or just maybe some delays.
Laura, I think maybe the slides have timing in them. So through Kathy's presentation, I was having to overrule the timing.
I gotcha. Let me just see if I can, I've requested control, so let me just see if I can go back here. Might not be able to, but that's okay. This is just going to be a fun, yeah, okay. I think I've got it, unless you're doing this.
No.
Yeah, it's got a bit of a mind of its own, so I just want to say thanks to everybody for your patience here. And I just want to introduce myself. Bernine gave me a lovely introduction. I saw Catherine Fox in the chat from Bryson, Quebec. I'm just across the, this is just going on its own. I'm just across the bridge from Bryson, Quebec. My family is also just downstream from Chalk River. So that's sort of where the situation of my research in this sort of arrived. This is a little bit distracting here, but so my research engages both with sort of how we can work to strengthen the law to strengthen Indigenous jurisdiction. And I started this from an extractive context, as you'll be able to see as I sort of talk a little bit about this report that we did that illustrated some of our research on Indigenous-led impact assessments. But given the scope of this research project and that it's intended to broaden over time, and given that my dissertation research is on consent mechanisms in nuclear waste siting in Canada, particularly in Ontario, I'm looking closely at how applications of consent can apply to, for example, the near-surface disposal facility in Chalk River, Ontario, close to Catherine and I. Right now, I am in Toronto as I'm doing my my dissertation research at York University, as Bernine mentioned. So I'm not there currently, but that is where I call home. That is where my family settled many, many years ago, and that's where we remain. So without further explanation there, I'm going to go into a little bit about this this report that we did. We actually had a launch event yesterday, but it demonstrated some of the things that we thought about from an academic perspective of how this was from a grant from the Impact Assessment Agency of Canada. So because there has been sort of such an increase of impact assessments being called or titled Indigenous-led IAs, we wanted to look at what that really means and whether or not we could sort of look at some characterizations that would maybe align as criteria for what would an Indigenous-led IA be considered. Ultimately, we came to the conclusion that Indigenous control must be central in the process and in final decision making. So when the state still holds unilateral power, is that something that we can still consider an Indigenous-led IA, or ultimately must there be consent and even veto opportunity for Indigenous communities? And we chose and selected some case studies of IAs that had already been ongoing, and some of them worked in conjunction with the Crown IAs, and some of them worked completely outside of the Crown framework. Some of the questions that drove our research here are how do and how can, where is there space for Indigenous-led IAs to articulate with the Crown impact assessments? Whose laws govern the impact assessment? How is power mediated in these contexts? And what types of compromises are made when Indigenous Crown and Crown IA processes become integrated instead of being accepted as separate and vital structures in their own right? And so I'm gonna take the move here and go to the next slide and hope that it doesn't just continue on its own. Gonna try again. Nope. Okay, so here are some of the, this is adapted. I'll let that go back. I'll see if I can just plug it. So these are some criteria when it becomes on the screen there, the defining and conceptualizing Indigenous-led IA, that were really, they were in collaboration with and lent from the Gwich'in Council's report called Emergent, if you can, Brennan, just to go back to the slide that is on defining and conceptualizing Indigenous-led IA. So it lends really from a report entitled Emerging Practices of Indigenous-Led Review from the Firelight Group and Gwich'in Council. And then we built on that in collaboration with some of the authors and with other First Nations practitioners of and Inuit practitioners and Métis as well, of what needs to be included for something to be considered an Indigenous-led IA. Central to this would be that it has to be completed prior to any approvals or agreements or consent being provided for a proposed project. So the community should be able to determine whether or not they want to consider a project on the lands that are in question. They can also have no-go zones. So if they've already determined an area to be sacred, or to, for example, in the peatlands, in an area that is just really ecologically sensitive, or if there are criteria that have emerged from a previous impact assessment, that this would happen prior to a proponent moving forward with their proposal. They also should be undertaken with some degree of control by the affected Indigenous parties and on their own terms and subject to their own approval. Structured according to the Indigenous Nations determination of the scope, and this includes methods for data collection, which we can also, I'll get into a little bit more when we talk specifically about the near surface disposal facility. Also with follow-up and monitoring, some of the case studies that we looked at, particularly in a modern treaty framework, would allow some control by Inuit communities and participants engaging in the impact assessment. But when it came to follow-up and monitoring, a lot of that authority was sort of taken away and become a part of the Crown process. And this is particularly important when we're talking about a project that will endure past any of our livelihoods when we're talking about radioactive waste. So they will be going on for many, many, many generations, and there must be some authority from a community perspective of how those processes go. They also must be governed by a process determined by local realities, capacities, challenges, priorities, practices, knowledge, and relations. So this could mean, you know, there's an emergency going on in the community, limited capacity. The timeline set by the proponent or the Crown won't work in this situation. This could also be the community requested an in-person oral telling for review. This doesn't mean that it can be done virtually or via sending hundreds of pages of papers back and forth. There must be, it must be structured according to the local realities and practices identified by the community who would be affected. And lastly, this was an outcome directly in conversation with some of the principles that we went over when scoping this project, that they must be subject to the applicable Indigenous legal order and oriented towards maintaining the life-affirming practices that flow from the reciprocal relations with lands and waters. So I think that's a really central part of this. And yeah, one of the things that we look at is how much room is there to maintain and to centralize Indigenous legal orders within the current Crown frameworks. And I'll talk about that a little bit more. So the next slide looks at some of the key messages that we that we aim to deliver to the impact assessment agency when we're talking about how to sort of operationalize Indigenous-led assessments. And that is, given the scope of review that we did, all of the assessments conducted by Indigenous nations were undermined by a background conditions under settler law, which continue to fail to provide true consent mechanisms. So again, for example, I have heard in hearing processes when FPIC or consent has been asked for from a community, the proponent responding that their obligation is to consultation and that consultation does not arrive at a veto. So that undermines the process of Indigenous-led IA. A true consent mechanism must be an outcome. The degree of authority that an Indigenous nation can achieve through Indigenous-led IA varies according to many factors, including the legal status of the land in question, again, under settler law. However, despite some of the shortcomings and constraints of being able to apply Indigenous-led IA within the current Crown settler law context, we also have heard from that many communities that engaging in the process of Indigenous-led IA really energized communities, revitalized laws, and strengthened their connections to the land, their law, territory, and community. So in order to reach the transformative potential of Indigenous-led IA, we need to continue to push for new interpretations and meaningful recognition of inherent Indigenous jurisdiction within the Canadian constitutional order. So that is a practice that is ongoing. That is something that we are actively engaged in, and that is something that any Indigenous-led IA and a lot of the very active roles that communities are playing will help to push towards in the future and now. The next slide is sort of just an overview of these points. So we can actually probably just skip the next one and move on right to the next one, which just adds a little bit more. So just in terms of these, oh, sorry, one back, and then I'll be done and pass it on to Kathy. So just in terms of the context of selecting case studies, one of the main challenges that we had was developing an overarching framework for a case study analysis of Indigenous-led IA, because the approaches and responses to Crown impact assessments are so different depending on several factors that include where the development or project or waste siting would be in Canada, particularly the treaty context, the historical impacts to the community's capacity, and in the Indigenous nations' relationship with the Canadian government or proponent. So we oriented the case studies around the broad question, how did the community operationalize its impact assessment in relation to the particular project? Depending on the nature of each project and community, the issues discussed would really widely vary. And also the development of the IA process would vary depending on the processes that existed already at the community level, and also how much practice or confrontation the community had already had with development projects and how much engagement they've already had with previous IAs. So this also, some of the case studies also focused on whether the community was able to participate via a government-led or a co-managed process, or also any other structural impediments. So when we looked at communities' interest in providing, for example, Indigenous knowledge in maybe a co-managed process or a government-to-government process, that would be very different. Oftentimes in a co-managed process, there was a lot of feelings of frustration and eroded trust, which prevented communities from wanting to give their valuable time and resources to providing this knowledge if it wasn't going to be, I don't want to say integrated, because if it isn't going to be valued really as part of the assessment. And also some of the ways that Indigenous knowledge was received from proponents or regulatory boards was not appropriate culturally or socially. And Another aspect is that settler law, when it engages in environmental assessments, is grounded in a Western and scientific worldview, and it fails to accommodate the epistemological differences that are inherent in what an Indigenous-led assessment would carry. I think that this is illustrated very well in a nuclear context, where oftentimes Western science and Western worldviews are really prioritized over community perceptions of risk or Indigenous knowledge of what the risks would be of a particular project, not only in terms of waste siting, but also on the front end of the nuclear fuel chain when we're talking about, for example, uranium mining. And then the other two, I've been speaking on this slide for a while, so you've probably had a moment to sort of review them, but they are related. So the way that Indigenous-led IA is structured typically doesn't look at the resources that are required to be articulated into an impact assessment, sometimes called high value components by the Crown framework. They don't look at them separately. And oftentimes it would be a more cumulative assessment that would look at the entire traditional territory rather than where the proponent assesses the structures or the barriers or the grounding of the region that should be assessed would be. So these are just some of the unequivocal aspects of Indigenous-led IA and Crown IA, and why we think that they should be not only permitted but respected and valued in a separate structure so that they can both operate and ultimately that given all of the knowledge that is available, that the community who's going to be impacted and who has treaty rights to the land would be able to make the final decision and not a unilateral decision or proponent-led or lobby-led decision. And I will pass it on to Kathy to talk about energy justice. Thank you.
Thanks, Laura. And not just treaty rights, but unceded rights too, where they hold the land incomplete. So yeah, my dissertation is on energy justice for the Anishinaabe, and I'm looking at that at fossil energy and at renewables through this. And my work is centered on the Anishinaabe, but there are similarities with the Algonquin, but caveats. Not every Indigenous community is like every other Indigenous community, and there may be differences depending on where you are working. But I'm looking at fossil and renewables. These justice theories and applications, however, are obviously just as applicable to nuclear and to waste disposal. I just as an aside, one of the communities that I've been working with about renewables is developing its own impact assessment process for projects to be carried out on the ceded territory, which is pretty interesting. We're going to be following that with interest. Next slide, please. And the next. Energy justice theories through history form the foundation for thoughts on energy justice. So justice in criminal justice terms, we're all aware of what that means. If you commit a crime, our system punishes you or makes you try to make up for it, restore the situation. So retributive justice and restorative justice are parts of that. They can also be appropriate in land rights as well. When we're talking about reconciliation, some of these principles ought to be brought to bear. Next slide, please. Recognition is one that's vital to what we're talking about today. It emphasizes the recognition of human dignity and of the difference between subaltern groups and the dominant society. In the cases in front of us, recognition as the owners of the land or the country and the treaties that would be required for any other country to assert any jurisdiction over lands that are held by a different country. So you can understand it in terms of Canada and the US, there's a border, and neither can unilaterally decide to change that border. If there is land within the exterior boundaries of the country of Canada that has not been ceded, it is not Canada. It belongs to some other nation. And a treaty would be required for Canada to assert any jurisdiction over that land. This is not a comfortable prospect for Canadian governments, but just because the project of conquest was incomplete in the 1800s does not mean that in 2024 we have to set about completing it. Conquest is shameful. Beyond recognition, procedural justice. This is something that Laura was focusing on, the ability to participate in decisions, to make the decisions themselves. Who gets to make those decisions? Who gets to participate? Are the decision makers unbiased? Are there processes for redress? So this is a familiar thing to all of us who've been working in environmental assessment at any level. Procedural justice can sometimes be a frustrating thing to try for. Next slide, please. But the ultimate one that creates a huge justice issues around energy writ large, the energy all around the world, are the principles of distributive justice. Are the outcomes proportioned fairly among all of the people involved? There's costs and there's benefits to energy extraction, transportation, and use. And are the costs being put on one set of people while the benefits are going to another set of people? That would be an injustice. And there's been huge examples of injustice all around the world. For example, where oil is extracted, ranging all the way to genocides that have been carried out for oil. So distributive justice gets the lion's share of the attention on this. Sovacool, who I've referred to here, is a leader in theorizing about energy justice. He's located at Surrey in the UK, and a lot of his work is focused on Western European ideas of justice. So the next slide will get into a lot of Western European ideas about this. He's broken it up into two principles. A prohibitive principle says that you have to construct your energy system in a way that they don't interfere with the ability of people to get those basic goods to which they're justly entitled. Problem with that is, what basic goods are people justly entitled? In certain jurisdictions, like where I came from, healthcare isn't something to which we're justly entitled. And some places don't consider food something to which you're justly entitled, or clean air. So that becomes an issue to discuss. And then the affirmative principle is, if any of the basic goods to which people are justly entitled can only be secured by energy services, then you have a derivative entitlement to those energy services. And here's where we came into some stuff during the pandemic when people needed to work from home. And so everybody's paying for their own energy and their employer isn't anymore. And energy became expensive for those who lost work, lost out on work, and lots of difficulties there. I have a paper out about that if you want the reference. Next slide, please. Sovacool did recognize that he's a white male. I guess he noticed it in the mirror. And he said that there is a need to strengthen energy justice theory with research from non-Western justice theorists. And he spelled out Indigenous perspectives of the Americas. So on that basis, I decided to write a dissertation about it. But he also, and I don't know why, specifically pulled out valuing the non-human world, life-centered theories of justice, and ecocentric theories of justice, which seems to me that these two bullet points are a bit overlapping. So next page, please. Next slide. I said Indigenous ethics here. These are Anishinaabeg ethics. They will be extremely similar to other on Indigenous groups on Turtle Island, but there will be slight differences. So take them with a grain of salt. But in Anishinaabeg ethics, Aki is a being, and mother to all life, land, and water are sacred. Humans are the lowest life form. This is a big difference from the Judeo-Christian ethic, where we are the pinnacle and made in God's image. Here we are the lowest life form. We're the most recent arrivals. We're newbies, and we don't know as much as the rest of life. Everybody else is wiser than we are. They're our older siblings. In addition, all the other beings have agency and rights equal to humans. the land as a provider and a teacher. Resources don't exist. There's no such thing. There are things out there that we do get to use, but only if consent is given. We can't just take, and we certainly can't take and hoard beyond our own needs. That is offensive behavior. That's shockingly greedy. Something that I was just given a couple of weeks ago by an elder Anishinaabe. If you harvest and then you find that you are not saddened by the fact that you've taken a life, and that could be an animal, a fish, a plant, any life. If you're not saddened by the loss of life, stop harvesting because you're doing it wrong. And when I think about that one, I think that one maybe has the most potential to save us from climate change if we could apply this to energy. Next slide, please. Someone has applied Anishinaabe ethics to energy in a 2020 paper by Oasis. They define a word in Anishinaabemowin, guabao, which is to take something out of fire using an implement. And so they use this guabao to mean energy. And Chiinakagwewin Anishinaabe law that can be observed in the environment and helps good relations among humans and with the natural world, and says harvesting principles from hunting and gathering could be applied to energy. So don't take more than you need. Don't waste. Don't be greedy. It belongs to everyone. It is not for anyone to grow rich from this. You need permission to extract energy from what Aki provides. That these rocks and wood and oil and wind all are beings that have agency, and we need to ask them permission to be able to do what we would like to do with them. Next slide, please. And to contrast that with Western Judeo-Christian ethics, this one sums it up. This is a quote from Terry Pratchett's novel, Carpe Jugulum, where the witch is talking to the preacher. There's a discussion about the nature of sin. What, are they against it? Not as simple as that, not black and white. And she says, no, there are no grays. There's only white that's got grubby. Sin is when you treat people as things. That's what sin is. And he argues. And she says, no, when people say things are a lot more complicated, that means they're getting worried. They won't like the truth. People as things. And so this can kind of encapsulate Western European ethics. And as we develop our ideas, the real question is who gets to count as people? Next slide, please. The definition of who's part of the community versus who's a commodity has shifted. Who's defined as a person? It's not even been 100 years since the person's case was decided in Canada, saying women counted as people. Non-white people, of course, have had many struggles being considered a person. Children haven't been considered a person. In fact, most states in the United States, you're allowed to beat them. You can't beat an adult. If children were persons, you wouldn't be allowed to do that. Non-Christian peoples were allowed to be completely, have all their human rights completely trampled. So, I mean, in the quote from Reverend Martin Luther King Jr., the arc of the moral universe is long, but it bends towards justice. The bending of this towards justice is in expanding the definition of what is a person. And we could not go more right than by expanding the definition of a person to include what Indigenous peoples have long felt are people. There's been personhood declarations for Mount Taranaki and the Wanganui River in New Zealand, the Magpie River in northern Quebec, the Klamath River in Oregon, Los Cedros in Ecuador, Lake Mary Jane. But why go river by river, mountain by mountain, wetland by wetland? Why don't we just recognize that Aki is a person and has a right to exist and has her own bodily autonomy and needs to be asked permission? And when we need to take something, we should think about the next 7 generations, and we should ask permission, and we should listen to the answer and not take for greed. Go on. Next. This will be Laura again.
Thanks, Kathy. Yeah, I think this is really great to break it up in this way. So thanks for doing this. So, you know, earlier when I sort of talked about this, when we were trying to scope the range of Indigenous participation in impact assessments, and what could be considered an Indigenous-led assessment under that criteria that we sort of looked at earlier. Maybe it will surprise you or maybe it won't, that when we looked at the willing host model, it sort of looked like this gold standard of what we're looking for, because there's an ability for there to be a veto. It's sort of spoken to as like, we have so much trust in our project and in our process that we will bring it to the community, and the community will be able to apply or withhold consent. So in theory, that model is excellent. I'm sure that there are many people on this call who have been engaged with the process of the willing host consultations and the willing host model, with the citing of the deep geological repository, that might disagree that that's how it has been working in practice. And so that is, I think, the next challenge of this. If we are trying to look at how communities can determine consent and then apply consent, we also need to look at some of the ways that, you know, governments or decision-making or regulatory bodies or proponents might try to sort of engage in that process and maybe manufacture consent. And we've seen this happen in other sort of ways where, you know, Crown or governments, decision-making bodies will say, like, we've got consent and approval from this community because, for example, an impact and benefit agreement has been signed. But oftentimes when the impact benefit agreement is signed, it's because there's an understanding that the project will go forward anyways, and a community is trying to get some benefits from that. And then, so sometimes that can be considered, you know, like consent by contract. And I would be really happy to share a resource on that by my supervisor, Dr. Dana Scott at Osgoode Hall Law School, just in terms of the context of impact benefit agreements. But I think that we are seeing it sort of happen again with the willing host model, and with some of my colleagues who I'm engaged with on the other side of the border in the States. There's this application of consent that is going to be sort of more broadly applied outside of just the deep geological repository, which is sort of the only way I've really seen this sort of standard used. But again, I think that there have been some pretty muddy details. What's that saying? The mud in the details. The devil's in the details. Seeing how it actually plays out actually might not be as perfect in practice as it is sort of in theory, in the way that it can be seen on paper. But I do think that some of the benefits that come out of, thank you, Wendy. Yes, the devil is in the details is absolutely what I was looking for. So the next slide just shows sort of, as maybe many people know, the Saugeen Ojibwe Nation was initially proposed, sought out by Ontario Power Generation to site a deep geological repository for lower intermediate level waste. And the Saugeen Ojibwe Nation came together and actually have a great deal of resources available to work with community to determine how decision-making mechanisms would work, and to determine whether or not the community wanted to agree to have a deep geological repository for radioactive waste on their land. Ultimately, they voted no in a referendum, and OPG walked away. Now, maybe many of the same people know that the Nuclear Waste Management Organization, or the NWMO, is coming back after having bought a large plot of land near Teeswater, but sort of have two different siting spots in mind, and they will be coming back again to the Saugeen Ojibwe Nation to try to determine if they can have consent for a very similar project. So during the the time of sort of participating in this process of determining whether the community wanted or not to apply or withhold consent, the Saugeen Ojibwe Nation developed some resources, including this consultation process resource, which I just think is fantastic. It's sort of a document to provide to proponents to say, like, before you come to us, have you done this checklist? Here are the things that we need as part of our process for you to consult with us. I can't say if that has been effective, but I do think it is. It's really, I think, something to celebrate in terms of capacity building on behalf of the work and the revitalization and just the power of the community to do so. And the next sort of little picture here is of Kebowek and Kitigan Zibi Anishinaabeg's joint assessment, Indigenous-led assessment of the near-surface disposal facility that is proposed to be and has been, spoiler alert, this is sort of for the end, but has been approved by the Canadian Nuclear Safety Commission in January to be sited very, very close to the Ottawa River on unceded Algonquin territory. So, you know, there are a lot of qualms with this, and it's also not over yet. But one of the outcomes of this, and something that I sort of spoke to before about the benefits that can come out of something, even if the challenge of Indigenous authority and decision making hasn't been met, are these wonderful aspects of data collection and community and capacity building, like what came out of the impact assessment here. And I will say, from what I've heard, there was a lot of structural barriers to being able to conduct the assessment that Kebowek and Kitigan Zibi did. One of the reasons, among many, for anybody in this space who really engages with nuclear infrastructures, particularly I think at Chalk River, though I'm sure it's similar to this everywhere, but there's a great deal of secrecy that is sort of just embedded with nuclear projects. So that can really give the proponent or the site locator the ability to just sort of to use that as the authority, like, because of national security risks like this, you can't come onto the site to these specific spots or at these specific places or at these specific times. And so it's really, despite the fact that, again, this is on unceded Algonquin territory, there are a lot of restrictions for community to be able to access this land and conduct their assessment. But despite these challenges, a really fantastic resource that came out of this is their assessment, and also a story map as well, which I will link in the chat once I finish up here. And to Ray's point, I noticed a question that was raised by Ray, is he made a great point that during the hearings in 2022 in Pembroke, it was said we don't need consent. And so Kathy gave this really fantastic overview of the United Nations Declarations on the Rights of Indigenous People, which Article 29.2 speaks specifically to citing a hazardous waste, a radioactive waste facility on Indigenous land without consent is not something that should be done. And this was one of the things that the legal team really brought up during these hearings, but something that was articulated and repeated by AECL or CNL was that they don't need consent. Their obligation is to the duty to consult. So the next slide looks at it's just a small screen grab from the Canadian Environmental Assessment Agency, with now Impact Assessment Agency, but the near surface disposal facility, the EA, the environmental assessment, happened under SIA 2012. So this is just a small screen grab of how under SIA 2012, the duty to consult is sort of captured. So another thing that was repeated is that the duty to consult is the duty to consult and accommodate when appropriate. So despite the fact that Canada has, the United Nations Declaration on the Rights of Indigenous People Act received royal assent in 2021, and in 2023, the UN Declaration Act Action Plan was developed. So there are these moves towards UNDRIP sort of being implemented, but really the devil in the details comes down to how it is interpreted into settler law and when it is going to be mandated to be applied into law, when there will be a requirement for proponents or the Crown to utilize the acts of UNDRIP that apply to consent and Indigenous decision making. So the next slide, these ones we can go through fairly quickly, but the next one is, I just wanted to note that under the new Impact Assessment Act 2019, it's called the offer to consult, not the duty to consult, though the obligation remains the same because of the next slide, which shows the Government of Canada, the Crown, has a duty to consult through the Honour of the Crown in Section 35 of Canada's Constitution Act. So when there is a federal impact assessment, the duty to consult, it applies, and it actually is supposed to be the responsibility of the Crown to conduct this duty, but oftentimes it is passed on to the proponent, which can create a lot of challenges and a lot of issues with transparency and accountability as well. But yeah, sorry, Brene, the next slide there just sort of does another little screen grab. These are all available just on the web. If you look at the duty to consult under SIA 2012 or the duty to consult under the IAA 2019. And yeah, again, if we look at Section 35, that's where it is situated in stone, as you can say. So the next slide is just to talk about the near surface disposal facility that has been proposed on and licensed on unceded Algonquin territory. So this facility has been proposed to deal with the legacy waste on site at Chalk River Laboratories. This waste has been characterized as low-level waste by the proponents. So they have said in hearings and in their communications that the waste that will be entering into this facility, this mound, which some people have different names for, would be things like contaminated clothing, cleaning supplies, and other like non-radioactive legacy wastes as well that might be toxic or hazardous, and they could be from any CNL facility. So one of the questions that we have is why is there this discrepancy of consent or for the willing host model for a veto opportunity between two different types of waste facilities? Some of the answers to this have been that the waste that is intended to be at the near surface disposal facility is in situ, so it's not intended to be moved. It's waste that is already at the site that needs a safer housing container. One is that it's not going to be buried, and that it will not be in a deep geological repository, but instead it will be in an above ground mound. So these are some of the answers that we've gotten to why there is this discrepancy of consent, but that has not been accepted by the communities who are really adamantly opposed to this project. And so despite the fact that there has been a licensing approval by the Canadian Nuclear Safety Commission for the near surface disposal facility, the Kebewek First Nation has just filed for a judicial review, a request for judicial review of the CNSC's decision. And this has a lot to do with the procedural inadequacies, including the procedural inadequacy of the way that the duty to consult was charged. But also because of some of the findings from the Indigenous-led impact assessment, such as the observances of foxes and wolves, and also other types of wildlife and species that weren't known to be on the site in the numbers that they are, and that might have an interaction with the Species at Risk Act and might actually require the site to be located elsewhere. So I think that this just sort of speaks to, you know, when communities put in this extraordinary amount of work, this extraordinary amount of resources, and this extraordinary amount of their already limited capacity, there are positive outcomes, even if they aren't the decision that we want, but that by pushing towards settler law to sort of be more not inclusive, but recognize the validity of Indigenous law and Indigenous jurisdiction and Indigenous legal systems, then maybe there can be a more just and equitable framework in which we conduct assessments and make decisions on land that is not ours. So I have a couple more slides that just sort of go over the impact assessment, but I can also link that in the chat for anybody who's interested in the outcomes of that. And then one last slide that just sort of looks at when talking about legacy issues, one of the pretty significant legacy issues that was cited both by the Saugeen Ojibwe Nation and also by Kebowek First Nation in their assessment is that there has been a lack of historic consent in the nuclearization of their territories. So the Saugeen Ojibwe Nation said that they had never been consulted with or consented to the nuclear infrastructures that are on their land, let alone consenting to or being adequately consulted for the waste repository. And the same thing was said by Kebowek, who said the secluded area at Chalk River was never ceded by the Anishinaabe people, nor was it subject to a consultation. Kitigan, Zibi, Anishinaabe, and Kebowek First Nation never provided their free, prior, and informed consent to the development. It is instead the results of the dispossession and restricting of Indigenous peoples' access to their own territories. So I think that that is a central problem when we're looking at developments on Indigenous land and Indigenous jurisdiction, is that the decision-making authority must lie within the affected communities. Okay, I'm gonna pass it back over to Kathy, or maybe we'll just say thank you and sort of open it up to questions, because I know that there are lots. I think there might have been some juicy stuff happening in the comments while I was presenting.
So we're at the question and answer period. So I think that this probably doesn't need an explanation, but we'll ask you to limit your questions to questions, not comments. Use the chat for that. And please try to keep your questions short and to the point, and enter your questions separately. Don't load several questions into one post. So I'm going to stop the share, and we'll move to gallery, and we'll go to Q&A. So first question, actually, I think our only question waiting, Sandy Greer is asking if the slides will be available afterwards. And Kathy, I know you were typing an answer. I don't know. Kathy and Laura, are you both good with making your slides available? Okay, great.
Absolutely. I'm also just going to post some of the resources that I spoke to in the chat now for anybody who wants to have a look, both at the assessment and of the report.
Okay, great. And then I will also, not immediately, but I will also then pull any resources, any links that Laura, Kathleen, or others have posted in the chat. I'll pull those links out and send them out in a follow-up email. It'll take me a few days to get to that, but so we have a question coming in from Wendy O'Connor. What's the current status of UNDRIP? UNDRIP, is it legal precedent? Is legal precedent being established to give it teeth? So I don't know, Laura or Kathy, if you could talk about the UNDRIP action plan, what the status is, and if we've actually got any case law yet around UNDRIP applications. Maybe we could hear from each of you on that. Kathleen or Laura?
You go first, Laura.
Yeah, so the status of UNDRIP right now, my understanding of it is just sort of as I spoke to, that it's being considered for interpretation. So the government of Canada has suggested that governing agencies consider how it can be interpreted into law, but there is no legally binding mechanisms to integrate UNDRIP into law right now. So for example, like in the near surface disposal facility case where consent for the site was called for numerous times, the regulatory bodies were, well, maybe I won't even, I don't know that I heard the CNSC say this explicitly, but it was commented on many times that consent isn't a part of a part of the obligation of what needs to happen in this process. Consultation is. So consultation is often heavily used by, for example, if you look through some of the documents that are out there on the near surface disposal facility, they checked all of the boxes when it comes to consultation. But I think one of the issues with consultation is that it is also something that is very interpretive. So the proponent can say, like, we sent letters, we had phone calls, but what does appropriate consultation mean? If the communities who are being consulted say that it is not adequate consultation, I mean, it would be my inclination to take that at face value instead of the proponent who really wants something saying that their consultation duties have been fulfilled.
Yeah,
Great,
and
thanks,
I would
Laura.
just add to that no, there's no case law either. In fact, case law is going the opposite direction. BC Supreme Court decisions regarding pipelines going through Indigenous territory have basically indicated that the UNDRIP doesn't even exist on their radar.
Great. I mean, I said great answers, not great situation. Simon, I'm going to ask, I see that in the questions you said you have a question and a comment. If you could actually enter that, key that into the Q&A, then we'll get it up. A couple of questions from Mary. First question is, what is your opinion regarding the rights of Indigenous people along the transportation route in the DGR siting process? This would be in the Nuclear Waste Management Organization's siting process. And I'll just say before you answer, Laura and Kathy, the NWMO siting process is extremely flawed and designed. A few of us who are on the line online tonight were part of engagement with the NWMO in the 2007 to 2010 period, where the siting process was discussed. And some of the advice that was given them at that time was you have to define community and you have to set out what the measure of willingness, how willingness will be measured. And they, I think, quite purposefully did neither. So they've got really good graphic design, but the process itself is quite flawed. And in the context of that flawed process, Mary asked, what's your opinion regarding the rights of Indigenous people? So I think this would be UNDRIP application or other provisions along the transportation route. So not within, set aside the NWMO in the case of the Northwest is looking to a proxy community that's actually distant from the site, but what about communities along the transportation route for this or other waste projects?
Well, I think it'd be very clear that anybody along a transportation route would be subject to the same impacts as people in the community where the disposal site is being proposed. So I would think that under justice, rules, which aren't necessarily the laws of Canada, but under provisions of justice, they need to have the same considerations as any other peoples along the transportation route, and the same principles as Indigenous peoples where the proposed site would be located.
Thanks, Laura.
I feel like this is like from again the folks that I've spoken to about either of these assessments, the deep geological repository or the near surface disposal facility, is that the assessment around transportation is one of the very, very serious gaps in this entire regulatory dialogue. So I don't know that people on the transportation route are being considered really at all. And I think that that is one of the biggest problems, because I think that's also where one of the biggest risks lie, is in the transportation of this, you know, high level radioactive waste throughout the country. Because once there is a DGR sited, you know, where will this waste be coming from? And I think that's also one of the concerns of the near surface disposal facility, is that once there are these infrastructures created and constructed and sited, I think it might be fair to say, based on analysis of other types of extractive infrastructures that sort of take a lot of liberties once an EA has already been done and once a project has already began, that there is a lot more leniency for things in the following stages. And if the project is to be expanded, and we see this all the time as well in the nuclear industry, when we see, for example, Darlington being the lifespan of Darlington suddenly being added a couple of extra decades, when that's something that that wasn't agreed to when the initial environmental assessment is done. And so again, when I just take it back to when we're looking at what an Indigenous-led IA is, for example, the follow-up and the monitoring stages and the decision-making authority being central to the affected communities is really important to persist long beyond a project is decided on. Thank you for that question.
Thanks. And Mary's asked a second similar question around downstream communities, a second concern, not part of the engagement process. Is there any application under UNDRIP that could catch those downstream communities? How does UNDRIP or even the duty to consult apply to downstream communities? Could it? How you know, how could that be brought into effect? And I know we've got some downstream Treaty 3 people online tonight.
Well, again, it's there are provisions within UNDRIP for protection of water, and so downstream communities would have the ability within UNDRIP to express their concerns about the water that they depend on becoming contaminated by an upstream project.
Thanks.
Yeah, and I think this is also where, when doing the scope of an environmental assessment, the catchment area is really important. And in a webinar that we actually had yesterday, Chief Haymond of Kibowek First Nation said that they are upstream, but one of the reasons that they are doing, they're doing sort of like a larger territory land approach. And I think that that's something that's been very effective in some of the case studies that we've looked at, is communities, and I think we can learn a lot from pipeline politics here as well. Sorry, that was a comment for the transportation route that I'm plating in my head. But you know, a downstream community would be more likely to be included in the catchment area of an environmental assessment than, for example, an upstream community. But when we're thinking about water, and when we're thinking about a nuclear infrastructure, and there is the likelihood of tritium, for example, which is very dangerous to human health and really impossible to get out of water once it's in water, the concerns apply long long downstream from where the site actually is. So I think having like collaboration and community and these types of conversations that we're having now, where we sort of like share our concerns and share what we know outside of what industry is sort of communicating with people, and we share our perceptions of risk, and we share the concerns that we have, like these are the things that sort of build solidarity and movements and actually are really effective when it comes to protecting communities that aren't necessarily directly included in the assessment. And I just want to say, because I think I might have missed it earlier, but when I was talking about the categorization of wastes at the near surface disposal facility being things like being low level waste, I just wanted to mention, because I think I missed it, that there's been much debate and dispute about the characterization of the waste that would be going into that facility as being low level, because there will be some intermediate level waste as well. So I think having experts sort of participate in these assessments and participate in these review of the expert analysis and the expert documents has been really integral to information dissemination and overall protecting communities who would be affected, no matter up or downstream or drinking water.
Great. Thanks, Laura. I think we've got 3 more questions, and our time is 8:22, so we might just make it by our goal of 8:30. A question from Simon about what's being developed to improve literacy among Indigenous people for their rights on their land in terms of radioactive waste for this NSDF. Maybe I'll pass it to both of you, Laura and Kathy.
I just want to say that I think the communities that I've engaged with, Indigenous communities that I've been engaged with, have had an incredible amount of literacy on their rights and of the potential impacts and risks of the radioactive waste. So I actually think that communities like Kerouac and Kitigan-Zibi and other communities as well have actually been really, really strong leaders in sort of this information, the rights sharing, but there are additional rights as well that are like, there are legal clinics who can provide, summary advice about what your rights are when they have been infringed on because of environmental injustice, for example. That's available to everybody, but I do just want to say, yeah, the literacy that I've seen among communities has been incredible. And I really feel grateful and indebted to that.
Thanks. Kathy, did you want to add?
No, I have nothing to add about specifically about nuclear waste, but I do want to say that the understanding of the rights under the UNDRIP is pretty clear among the tribes and First Nations that I've been working with.
Thank you. Question from Cal, with the background of past ministers and past government players and their engagement on various terms with First Nations. Cal's asking, what are the parties in Parliament? Who are they going to? What are the parties in Parliament that are going to protect the interests of First Nations and environment? Are they all going to act the same and bulldoze over opposition to nuclear waste barrel? So, Kathy or Laura, if you've got any sort of assessment of the lay of the land in federal politics right now, is anybody home? Is anybody going to step forward to defend the land and Indigenous rights with respect to these projects?
Well, I don't know much about the bloc and what they would be offering, but they are confined to one province. I do know that the Greens would step up and protect, but we need to get them into Parliament. There's not very many of them. Of the ones that make up the majority of Parliament, I wouldn't count on any of them.
Laura.
Yeah, I would. I try really hard to keep my cynicism in my head, especially at things like this, but I would have to potentially agree with Kathy. I also, there was a really, really large engagement on Parliament Hill last week following the federal appeal for review of the CNSC's decision. And I did see a quote in there somewhere that I didn't want to see, so I'm trying to pretend that I didn't, but it was from the Honorable Justin Trudeau, who said the issue of citing radioactive waste isn't a political one, so we are going to trust our experts on this, which I think, like from what I hear in that, is that that there is like a differentiation of knowledge and expertise, and that the Western, as we sort of spoke about before, like Western science and the Western worldview, and these engineers who are a part of this industry that has very sort of niche understandings of very niche systems are the experts, and that the people who have had knowledge of the land for millennia are not the experts on this. So there's my cynicism on plate.
Yeah, exactly. The definition of who's an expert and who's not is one of the biggest problems, and comes back to that procedural justice issue and the difference in Western European ethics versus Indigenous ethics, and that stark difference in who counts as a person.
We have two more questions. Thanks for those responses. A question from Janice. Laura, you mentioned that radioactive waste can come from any CNL facility. If I understand correctly, CNL is made up of SNC-Lavalin and two American companies. Does this mean waste could be brought from outside Canada? I'm not that familiar with all this, but I wondered.
This is something that we talked about a lot yesterday as being a major concern of opponents to this project. So I can't confirm that with certainty. There perhaps is someone on this call who can, but that is a great concern that I have, along with others who are really engaged in this process. And yeah.
I could just add to that one of the deficiencies we have in the Canadian system is we don't have any registry of waste movement, of waste shipments. But in the US, there is the ATOM system operated by the Nuclear Regulatory Commission. And through the ATOM system, we've been able to track a number of export-import permits, and they are transfers of waste from Canadian facilities to American facilities, supposedly for processing. And what we see on those licenses is there will be licenses that will list multiple facilities. It might list facilities owned by Cameco, Ontario Power Generation, and Canadian Nuclear Laboratories transferring to a US facility for processing. So maybe for compaction, that's never spelled out, maybe for incineration, although there's incineration facilities. Unfortunately, Cameco and Ontario Power Generation operate incinerators for radioactive waste in Ontario. But then the return licenses, so that the rule in the US is that the residuals have to be returned to Canada. And in the import licenses for Canada, export from the US, they also list a number of facilities. So according to the licenses, waste could be coming from any of these facilities in Canada, moved to a US facility, and then returned to any of the facilities. But the most likely destination is the Chalk River site, the ACL site operated by CNL in Chalk River. So I think, Janice, that the potential is absolutely there, and the difficulty we have is in tracking that. Well, one of the difficulties we have, the other difficulty, of course, is that it's happening. So our final question from Anne. Have Indigenous assessments included the effects on most vulnerable members of their communities, for example, women and children, as well as more than human world? And have they also included the Treaty on the Prohibitions of Nuclear Weapons Canada nor the US have signed, which address particular harms to Indigenous people and women? So have you seen that either, Kathy or Laura? Have you seen in Indigenous assessments how those effects on more vulnerable women, children, elderly are addressed? Do we have any assessment processes that are mature enough that we can make observations on that?
Only that the one that I'm aware of was dealing with the renewable energy. It was a wind farm. And they considered not only women and children, but the next 7 generations. And the past 7 generations, they had elders go to the sites and eliminate sites from consideration based on what the ancestors were telling them. So, yeah.
Okay. Laura, anything to add? And then we're gonna actually wrap up.
Like, for example, the near surface disposal facility assessment done by Kerouac and Kitigan Zibi was led, like women were a very integral part of the assessment, particularly because they're the water keepers of the community. I think that youth were also involved as well, but I can't speak to the signing of the treaty. But I missed another part of your question, but I think it was sort of like seeing do they include like the not human?
Yeah.
Sorry about that. Yeah.
The other part of the question is about are they focused more broadly than impacts on humans?
Yes, I would say absolutely. And particularly if you're holding them sort of in parallel to like a Crown IA, extraordinary differences. So yes, I would say yes.
Great. Well, thank you so much, Kathleen and Laura. Absolutely great presentation. And I really thank everyone for the great comments and contributions during chat and the questions. And I'm going to just remind you that we have one more session in our Nuclear Waste Online webinar series for 2024. And that's next Thursday at 7 o'clock. Radioactive waste and policy, where did it go? Many who are online were part of a really intensive effort engaging around the radioactive waste policy review convened by Natural Resources Canada 2 years ago now. And so we're going to look at the outcome of that policy review of the integrated radioactive waste strategy, which the minister invited the Nuclear Waste Management Organization to develop. And we're also going to focus in on reprocessing policy, which was one of the key concerns raised by civil society during the radioactive waste policy review. So that'll be our wrap up for this series and also our wrap up on the radioactive waste policy review. So I hope to see many of you online next week. So again, thank you to Kathleen and to Laura. And I've just got some websites up online for follow-up. And as follow-up actions, I'll send out the links that were in the chat and links to the slides within the next week. So thank you again, all, and good night.
Thank you.
Chimigwech.